Scenario number 3. In a criminal case, State versus Johnson, defendant Johnson had been placed on probation, but had failed to provide proof to the court that he had enrolled in a substance abuse program. The judge ordered his probation revoked and a bench warrant issued. 2 days later, the defendant appeared voluntarily without counsel to request a payment schedule for the money he owed. The bench warrant was recalled, and the judge set a date for hearing concerning the defendant's ability to enroll in a substance abuse program. The judge then sent the defendant to her judicial assistant to discuss payment of the funds he owed. Later, the judicial assistant came to the judge's courtroom, slammed the defendant's file down on the sidebar, and told the judge that the defendant was not cooperating and that she could not work with him. The judge told the defendant that since he was not willing to cooperate with the assistant, he would be taken into custody, and she instructed her bailiff to do so. The defendant repeatedly asked the judge why he was being put in custody. The judge told him that he was going into custody because he was not cooperating with her judicial assistant. Judge Ash, what do you think about the judicial assistant's conduct? How would you deal with her? What education do you give to your own court staff on conduct?
Yeah, I don't know who wrote these scenarios up, but I've been involved in every one of them. So someone's either tailing me or something. My judicial assistant, who's now a lawyer and really a wonderful person, and I guess she knows I like people to be civil to each other. So what happened to her, I was up in court, 2 people are getting a divorce, are yelling at each other out there in the hallway in front of the door. She walks out there and tells the deputy to put the guy in the holding cell until I can take care of it. So basically the deputy takes him into custody, puts him in a holding cell based upon the directions of my judicial assistant. So I get off the bench and she comes in there and she goes, these 2 people were out there yelling in front of the room. I said, okay, so what happened? She goes, well, I told the deputy to put him in the holding cell. I go, where is he now? She goes, he's in the holding cell. I go, well, I'm going back on the bench right now. Bring the guy in. Told him I was sorry about this incident. Spent some quality time with my judicial assistant saying that she did not have the ability to incarcerate people, even though she did work for me. But it is a really serious problem. I take the cans of ethics, and I see Cynthia Gray back here. Cynthia did a great book about families, about teaching our families about judicial ethics and the impact it has on them and how families are to deal with it. And so I think as judges, we owe a huge responsibility to meet with our staff. I have a written comment that they go over with about how they're to act, how they're to treat people with respect, that type of stuff. And also, I didn't have my family sign anything, but we went over Cynthia's book about how to do that. One great story is this guy calls me and says, hey, Don, this friend of mine is getting a divorce. I need to ask you some questions about divorce. And I go, yeah, I'm on the bench. I can't really answer any of your questions, but thanks for calling. He said, well, could I talk to Rita? And I go, yeah. So he gets Rita on the phone. He starts asking Rita these questions. And she starts giving this guy legal advice. She was correct, by the way, by what she said. But still, we owe a big responsibility to instruct our staff, whether it's law clerks, bailiffs, other people, because they will use, not because they're mean people, they will use the power of the judiciary to influence conduct on other people. And they're clearly out of bounds on that. But I make a big effort on doing that.
Judge Jones, your own reaction.
Well, I don't know, you should say fortunately or unfortunately, in the bigger city, if you will, we don't really have as many people interacting in that quasi-judicial capacity. Nevertheless, it is wholly incumbent to me upon the judge to make sure that every staff member fully understands the limits that they have as non-judicial officers, just as you were indicating earlier. I think additionally, it's important to understand for judges, sometimes it's better, notwithstanding the cost, to make sure that what you do is on a record. So that you don't have these kinds of problems. And if you're going to bring somebody back in, as opposed to saying, I'm going to lock you up now, without counsel no less, I'm going to continue this matter to allow you an opportunity to obtain counsel, and you come back with an attorney, and we'll go from there.
Dean, I'm going to impose upon you from your own Chief Justice days. I mean, your reaction to this?
Well, my reaction was due process is a pesky thing. I didn't see a lot of it in there. I think, one of the challenges, though, and Chief Justice Muniz, who, by the way, was a great Chief Justice in Oregon, I admire him greatly. One of the real challenges the courts are confronting, and it relates to this issue, is the rising number of self-represented parties. In the district courts, 85% of the people don't have lawyers. In the Superior Court, the jury trial court, in my state of New Hampshire, more than half the people come one or both sides without a lawyer. In the Supreme Court of New Hampshire, where I sat for 15 years, in 35 to 40% of the appeals, one or both sides does not have a lawyer. So as was said earlier at the outset, I think by the Chief, you can't look at this issue of civility and judicial behavior and lawyer behavior without dealing with the self-represented piece. It's a huge piece of the puzzle of the 21st century justice system, and it imposes new burdens, and it forces sometimes court staff to think they're lawyers and give advice which they can't do. Judges get impatient with it. And most of the people who are there, by the way, like this fellow in the hypothetical, can't afford a lawyer. In civil cases, they can't afford it. So we can be cranky about it, or we can deal with it. And the court system has been reluctant to deal with it, but it needs to.
And any other thoughts on self-representation?
Yeah, well, yeah, I'll put a plug in for the Judicial College. About 7 or 8 years ago, they called me and some other people and asked us to develop a course just for judges about how to deal with self-represented litigants. It's a 4-day course. In fact, this week with current issues in the law, we've got 2 hours that we're doing that. So there's a conscious effort to help deal with that. The bottom line on this, on the self-represented litigant thing, is A, patience, which you just said. And the second thing is the judiciary has to become an instructor, which I didn't sign up to be a school teacher. But I've got to teach people when they get ready to walk in there, or somebody does hand out something, A, B, C, and D is going to happen. And this is why it is. And instruct. There are a lot of great videos. Minnesota's got a great video to help self-represented litigants. But we on the judiciary side have got to be more prepared for that, because it's really the perfect storm. I think in Maricopa County in Arizona, I think it's Maricopa, they told me 80% of all the filings, the people represent themselves. Wow. 80%. And so, now in grocery stores, you can check yourself out, and we can do all kinds of fancy stuff. People think they can represent themselves now, and more people are going to come. But like I said, I think the Judicial College did a great job on getting on the cutting edge of that to try to help educate the judiciary. More to do. A lot of great studies have been done, but I feel like we're making an effort to deal with that. But I think you're exactly right.
Mr. Wilkinson.
Yeah, our county court systems are seeing more and more self-represented litigants. As the economy has been in a downturn, the legal aid agencies have had severe cutbacks in their funding, and in the meantime, those who qualify for legal aid has gone through the roof, but the resources simply aren't there to help them out. Some of our county bars are setting up resource centers for self-represented litigants, and at the same time, our Pennsylvania bar and some of the major bars, including the Philadelphia bar, are working together to try to get a serious focus on civil Gideon-style efforts to close the civil justice gap. And we anticipate, in Pennsylvania at least, that there may be some Senate Judiciary Committee hearings on this subject as early as next month. So it's an ongoing problem, and we're trying to work on it and close that gap.
Ms. Lukey, your own reaction?
I haven't had any cases myself with self-represented litigants, and you wouldn't expect that to happen because obviously our cases, if they're paying our ridiculous rates, are probably against other parties who are also paying very large rates. But I have had the opportunity to watch over the last several years the evolution of how the judges and the courtroom clerks treat the self-represented litigants, and I am extraordinarily impressed. Obviously, they have been trained. We don't see the self-represented litigants much in the federal court, which is where about 60% of my practice is, but on the state side, there's been some form of excellent training. It may have been through the college, I don't know, but the judges show patience, the staff even though you can maybe see a little bit of the irritation seething, keeps it under wraps, and I think they do a phenomenal job. It's not easy. These people are in distress in most instances. Often there's a language problem. And Massachusetts is maybe typical, I don't know. Massachusetts actually has a law that requires the court, at the court's expense, to obtain a translator for any language before a trial can proceed with a self-represented litigant for whom English is a second language. Holds up trials sometimes for folks, but it's a very important thing to do. The translator translates for everybody.
There have been studies, I think justice at stake might have done it, but in any event, a study of self-represented litigants who lose their cases and how do they feel about it. And people who felt they were treated fairly, they're not happy to lose, but they're accepting of it. People who don't understand the process because the judge asked said the judge hasn't explained it, which doesn't seem the judge's role, but I think judges are learning to more neutrally engage self-represented people, and for public trust and confidence and civility in the system, it's essential. Absolutely essential.
Can't help but comment on the irony that we've got 50% of new law graduates without employment and what is apparently massive unmet legal need, and every study shows it. That it seems, and I know that there are efforts underway through various guided, supervised programs, but it seems as if we could intervene in ways that would provide representation, particularly in critical areas, and give new graduates experience, like family law, where the need is very pressing.